because of the COVID-19, situation that happened. All businesses were suddenly shut down, and of course, professional services were no exception, and so forth. And I think for that period of time, that 2 months, I think we're now in day 154 of the lockdown. It has really been very, very, brutal, because never has it happened that so quickly our lives can suddenly just change, unexpectedly and so forth. So where do we go to from here? We've seen that in many industries, there's been a lot of talk about assistance, about the new normal, about what's going to happen, so forth. And I really felt, as a legal practitioner, that there is no attention or rather platforms available for lawyers to discuss these issues and to try and find ways in which they could know where to go to from here. That's the first thing. The second thing is that as a lawyer, I don't see other lawyers as my competition. I see them as my colleagues, and I believe that the cake is big enough for everyone. And I believe that it's only through synergies, cooperation, and partnerships that we would be able, as professionals, to achieve the goals, that we set for ourselves, so that we are meant to achieve in our society. And, it is from that school of thought that there's a new saying that says that collaboration is the new competition. And it's not just for lawyers, it's for everyone in the world. If you look at the traditional models of business where we come from, throughout history, it's very interesting. I mean, think about, the Stone Age, and then you think of the Industrial Revolution. During the Industrial Revolution, for you to be in business, you had to have, thousands of employees. You had to build massive factories somewhere and make sure that you carry all that cost just to make sure you produce a can of fish to export to another country. But if you think of where the world is today, in this revolution where we're in now, the information revolution where we are, you don't have to have that anymore. You can literally not own a factory, not have one employee, but be able to do business. And it is from that background where you realize the importance of collaboration that we have as lawyers. And in fact, I remember vividly many years ago, I had a mentor from a retired international lawyer who's based in Amsterdam. And I was pleasantly surprised when he said to me that your biggest clients are actually other lawyers. Because we come across many different people in different industries. Sometimes we don't have the expertise to do that, to assist them, and the first reaction would be to recommend them to someone who would be able to assist them. So those are the two key reasons why we wanted to have this platform to discuss this today. Now, the Solicitor General, Mr. Pandelani, sir. Firstly, two things to you. The first one is congratulations on your appointment to this position. And I read your profile, and then my team will load it later on as we're discussing as well. And it gives me no doubt that we have someone who has skin in the game and who understands the background of the position that you are holding now. And I have no doubt that, based on what I've seen from you so far, that your heart is in the right place. So congratulations for that. But secondly, I would also like to thank you for being human. And what I mean by this is that, I've sat on some of the boards in state-owned companies and private companies, and sometimes I would be very surprised by the demeanor in which, board members or executives, CEOs, director generals, etc., relate to other people. It's almost as if, for you to get their attention, you need to have a history or a Porsche or whatever parked in their gate for them to give you recognition. And as a human being, I find that completely appalling. In fact, I remember Gambonani, a few months ago, you and I had this discussion where you said to me, Mkwanazi, if you can be appointed as a minister, as my friend, and then suddenly I have issues to see you or to meet with you or to even, get to talk to you, I will really have a serious problem with that, you know? And I guess it talks to the kind of leadership that we need to develop. We need to move from a leadership that is focused on what someone has for us to be able to engage with them, to a leadership where we engage with people. If I had to borrow a phrase from Martin Luther King, based on the content of their character. And I think for that, Solicitor General, I was pleasantly surprised by your humility and so forth. So thank you for that, and I really appreciate that demeanor that you have. And then, of course, in terms of what we want to achieve today, Solicitor General, you have been thrust into this. You know, I saw the press when your announcement, your appointment was reported on. Kept on referring to the Office of the Attorney General as chaotic. That is basically the buzzword that they've been using. So you've literally been thrown into a den, of various challenges that you need to, firstly, pedal to stay afloat, but also you also have your other responsibilities as a leader and as a citizen towards ensuring that our profession, gets sufficient work for lawyers to survive. And of course, to ensure that, issues around ethics, flow of work, briefing patterns, and all that jazz are being dealt with, in the right manner and in a most, empowering manner, so to speak. So I'm really looking forward to hearing you tell us today, as Solicitor General, what your role is in this chaos that I've just described. I'm interested in hearing, what your views are relating to, the status quo, which is COVID-19 that has happened. I want to know what your views are relating to briefing patterns in the country. And of course, I'm also interested in knowing, as a department, which is ultimately responsible for the oversight of our profession, what type of measures you have, in place to make sure that we are able to assist lawyers going forward. And then, of course, we also, as you saw in our flyer, have a tech element to it. There's a company represented by Mr. Daniel Makoni, who will also talk to us around legal tech for law firms in terms of, what the new trend is, where it's going to, and how law firms of the future are going to look like from a, automation point of view or from a tech point of view. So I'm very excited about that. And then, of course, I've already spoken about Ms. Dineo Beta, who's the director at Beta Inc., and she was going to share her experiences as a lawyer in terms of, the type of challenges that lawyers experience in our country. And then, of course, Mr. Ivan Gambonani, who's also a practicing attorney, and he didn't tell me this is a secret, so I'm going to say it, also advisor to the Minister of Rural Development and Land Affairs. That is, if they didn't change the acronym again in the past 24 hours, because it seems the department's name is always changing. But he'll hopefully correct me on that one. So thank you. He will, in a sense, also participate and share with us. But most of all, colleagues, I would like each and every one of us who's here today to leave here having gained something from this meeting. So please do also participate. And let's hear your thoughts. Let's hear your recommendations in terms of how things can improve. And let's hear, your contribution in terms of how are you going to get out of COVID-19? Are you out of it already? Are you still wondering where you're going? What is the game plan, so to speak? So I'm really excited about listening to all of this. So what we discussed with the Solicitor General is that I see, Patana, I see you are here. Are you going to speak on behalf of Daniel, or is Daniel going to do the presentation?
Daniel is here as well.
Okay, great. Thank you so much for that. Because what we're going to do, Daniel, as tech guys, we thought we don't want to burden you with our, legal issues that, which we can talk about for the whole year. So we're going to start with you from the tech point of view to give us some insights in terms of, what the direction is for law firms in terms of software, your experiences. I know you've played a very important role in developing some IP practice software for some law firms. And you certainly also assisted us as a firm by helping us to automate our firm as well and to set up, the necessary softwares that we need to manage the firm. So can you please, I'm going to give you, say, 15 minutes to please just take us through, your presentation on legal tech. And then when you're done, it will be entirely up to you whether you stay in and listen to the lawyer issues. But if you do, though, that's at your own risk, because it means we'll keep referring to you to ask you to add more as time goes on. So welcome, colleagues. And Daniel, I'm going to give you the first slot. It's going to be 10, 15 minutes. After that, I'm going to hand over to the Solicitor General. And then, of course, from then spot, our other colleagues will also be participating. So Daniel, welcome, and please proceed with your presentation.
Thank you, Ronnie. So I must just apologize. On my side, I decided to bring in Batanai because I had power cuts. I'm not sure whether it's load shedding or what it is, but there's no power. My discussion really around the tech and legal tech is just to look at the trends and where the technology is going. So, you know, and I want to kind of couch that in the South African context. So in general, you know, there's a lot of people bandying the fourth industrial revolution and what 4IR is going to bring and everything. And I want to just make a step back from there and say, well, we're not yet done with the second and third industrial revolution. So let's just hold on with the fourth. And let's talk about the tech that matters in the legal space, which is largely looking at the automation of processes. So the biggest challenge that we see is around document management and case management of tech management within law firms. So when we're talking about document management, whether we're talking about case files, we're talking about files that we've been given as lawyers to keep or to do anything, but that whole process around document management, I think there's a big drive now more than ever to more automate that, and not only automate, but to bring it online. So there's been a big aversion to online and cloud storage because of security issues in the past, but especially I think with the advent of COVID, we're going to see an acceleration of that cloud technology coming through within the legal sector. So I think more and more there'll be solutions coming onto the market, or people offering solutions around document and legal case management that will be cloud-based. That is one thing that's going to come through. Another area that has started to make waves in the legal space is around artificial intelligence and the use of chatbots. So I'd say we've probably all interacted with a chatbot before, we just didn't know that it was a chatbot. So you know when you go onto a website and immediately whilst you're looking for something, a pop-up appears and says, hi, can I help you with something? And is this something that you need? So 80 to 90, probably between 60 and 80% of those chats are actually automated, and it's a chatbot. So it's not an actual person that you're talking to. And what that chatbot does is it, by using artificial intelligence, it processes your requests and what you type in to be able to form a conversation with you, to lead you in a particular direction. So when we think about chatbots in the legal sector, there've already been a few examples of chatbots around how to direct queries or how to manage particular cases within larger law firms. So the chatbot would say, so what's your request? And you say, we have an issue with this. And then the chatbot would say, so maybe you need to talk to someone dealing with conveyancing, or maybe you need to speak to senior counsel before you go any further. So the chatbot would be able to configure based on how you'd set it up to be able to route or to give a user perspective on what their next step should be and how to assist them, whether it's to find a particular document, to find a resource, or just on general counsel or general information around legal matters. So many websites that normally would provide legal information can now be automated using a chatbot to give back more of an interactive view around the legal practices. So I think that's one trend that is really coming through quite heavily at the moment. And then another area that's going to, I think, make waves, or that has already started making waves, is around the analytics of cases and what happens in terms of data extraction. So you know, you have the big players, I mean, LexisNexis and all of that, who have been looking and trying to decode, if I can put it that way, or extract cases that have been launched, judgments that have been passed, and giving lawyers an interface to be able to search and readily access that information. So I think with the growth in capabilities around the data analytics and the ability to process language, we're going to see a greater rise in that space. And what that's going to do is, from a legal perspective, one, it creates an opportunity for us to see what is currently, you know, what matters are trending or what issues are trending. And so if you think about where do you want to focus your priorities are, you know, you look at the trends, you see what's happening, and then you then perhaps focus your firm in that direction. Or you look at it the other way and say, okay, this has already happened, so what next is going to come? And I think when we do that, we need to also then couch, and as lawyers, I'd say, to start embracing this technology, to look at it and see how can we adopt this technology for our own benefit. One of the biggest challenges around the use of technology and the legal space have been the lawyers themselves. So I'm going to give an example. Conveyancing and registration of deeds and bonds and everything. So that process, by and large, could be automated from the start to the end. But in the South African context, the reason why there is no system that can do that is because the legal fraternity went ahead when someone came up with a system about 5 years ago and said, no, we will not have this system. This has to be signed off by a lawyer because of the fear of what that technology would do in the space. Whereas if a collaborative approach would have been given, perhaps would have found greater synergies and reduced the cost of these transactions to better the legal fraternity and to better the experience for the people that we're trying to serve as lawyers. So I think there's this element where we need to start looking at how can we adopt technology more. Are we willing to automate our processes? Are we willing to trust the technology with managing and handling the issues that we need to deal with every day? So a simple example, like one of our products does with practice management, is a system that would then allow you and give you prompts and allow you to track your case on site. So if you have a multiple people working on a particular case, you want to have that information readily accessible. Everyone can access, can see what's happening. So you'd log in, see, even if you're not logged in, the system will prompt you and say, listen, in 2 weeks' time, there's a court date, there's an appearance, and are you ready? Are you going to prepare for that? The system needs to be able to prompt us. It needs to be able to guide us and assist us in our actual activities, and not have us focusing on things that computers are better placed for us to do. So I think those are some of the key trends that I think are worth mentioning at the moment, and to see what happens. One more thing is, you know, as Mr. Mkwana said, you know, collaboration is the new competition. And even among sectors and practices and professions, you know, so there is this gray area, if I can call it that, or this space where more and more the legal fraternity needs to be integrating and collaborating with other professions. So whether it's from the supply chain and its contract management, or it's risk management, you know, or its governance structures. So more and more the systems that run legal activities or legal practices need to be diversified to allow for that collaboration to happen with different role players. So it's not just about what the lawyer sees, but it's what an organization would see. It's what would matter to everyone in the context of that organization, and even creating portals that can allow clients to externally access and see what's happening, because there is a drive in the current context where clients want more transparency. They want to see what's happening in their cases, and having a system that can allow you to look in and see where my case is, what's happening. That transparency builds trust, creates a better relationship, and what will happen, what will result from that is you get more business as a legal firm, or because someone can trust you and say, well, I know he's open, he can show me what's happening. And it's not this black box where a client feels at sea and can't even relate or interact with you around their own issues. So in a nutshell, I think that's what I'd like to talk. I hope I didn't exceed my time. I get excited sometimes when I think about where things should be going and what should be done. But quite happy, and thank you. If there are any questions, guys, please feel free to ask, and I'll stick around, Ronnie. It's always good to hear what's happening and to know what matters in the legal space. Thank you very much.
Okay, Daniel, thank you very much for that input, which was basically an overview, I suppose, of what the challenges are from a tech point of view in I suppose, like you said, not just about the 4IR, but the fact that we have skipped some stages as far as we're concerned. But I'm particularly surprised by what you said, that there seems to be some form of resistance as well from some legal practitioners around adopting IT, and I suppose that also has to do with the type of work those lawyers would be doing as well. But I'm hoping, Daniel, perhaps that maybe before you guys leave, I don't want to put you on the spot, but if you do have some form of 1 to 5 minutes, what do I call it, process flow, that where people can actually see what you're talking about, I think that would be great. But for now, thank you for that. I think that was a great input. Colleagues, are there any questions on this particular issue? Because as you know, we want to move on to the legal leg of our discussion. Are there any inputs around the tech issue? Questions, inputs, ideas? Maybe even share with us what system are you using and how you find it. I will dedicate about 5 minutes to this discussion. Any inputs, colleagues? Maybe for me, whilst our colleagues are structuring their questions there, is that, especially because you started with a 4IR as an entry point. What I really find very disturbing, and this is purely as a human being, is that we are talking about 4IR and the rolling out thereof, and of which the custodian of this is supposed to be the state. But guess what? Most state departments do not have Wi-Fi, right? There's no Wi-Fi in most state departments. In fact, if there's anyone who'd say to me their department has Wi-Fi, I think I will give them an award for that. But there isn't, for many different reasons. And to me, that is a problem, because if you want to accelerate, technological advancement in society, you cannot do it if you cannot connect to Zoom from your laptop, because the software is being blocked, and so forth. So how do you think we will be able to do this, Daniel, without, investing in infrastructure for connectivity?
Yeah, and that's why I said 4IR in many senses is still a pipe dream, because the fundamentals around infrastructure, so connectivity is the primary aspect that we need to be focusing on, and not just from a public sector perspective, but even within organizations. What value or what priority do we actually give IT and ICT solutions? So whether it's thinking about telephony and integrating your telephony to your fax, to your emails, to your cell phones, to roaming numbers, how much value do we place on that, and do we yet see the benefit that's inherent in rolling that out? So if you're running a law firm and you're not willing to pay more for a faster internet connection, then any software, anything you do in that is going to be hampered, and you're wondering, why are you lagging behind? But it's that fundamental to say, first, let's fix the pipeline. And then when we fix the pipeline, let's see what are the critical processes that we have in the organization that would benefit most by bringing some technology to assist us in running that. So I really think that definitely, from a public sector perspective, a lot more investment needs to happen. There needs to be more collaboration around that investment. It shouldn't just be, say, for example, CETA trying to roll this out, but it should be the professionals should actually be driving the IT departments and IT professionals to give them solutions for their problems, and not IT departments or IT professionals coming to beg and say, hey, here, this is good for you. No, it should be the other way to say, listen, I need something that's good for me. What do you have? And I think that mindset shift is something that will be critical for the fraternity to move forward and to really start adopting these technologies.
Okay. All right, Daniel, thank you so much for that. Albert, do we have any hands raised that I may be missing that I'm not seeing?
No hands raised, sir, but the folks can unmute themselves if they have any questions.
Okay, and colleagues, you can also type your questions in the chat box to your right where it says type message here in the chat. So if you have a question and maybe you're too shy to talk to us, I would be surprised why, because you're a lawyer.
Maybe let me come in with a question.
Okay.
Is Gambonane here? Daniel, I'm
Welcome,
asking this. Thank you very much. Daniel, I just want to ask about how do you think as lawyers you can assist to change our mindset in terms of embracing and welcoming technology? I'm saying this because our profession is very conservative, and that's how we are trained, of keeping liver arc files, of writing when you consult, writing on paper, and having storeroom where we keep files. Even in terms of the rules of the Law Society, we are forced to keep files for 5 years and so forth. We train in that way to keep boxes and keep documents. After 5 years we can dispose. How do you think as lawyers we can change our mindset to accept these technological advances and be able to use more of these tech resources in order to advance our profession?
Yeah. Thank you for that. I think that's a really good question, to say, how do you change mindset? So I read a book many years ago that had a simple title and said, pressure brings change. So what will simply happen is, in this context, or the way things are going, if the fraternity does not evolve, it will be overtaken by events. So we're saying, oh no, but this is legal and we can do this for so long, and but let's think about, look at situations like Uber, look at situations like Airbnb, where overnight parallel or a totally new space was developed that sidestepped existing and largely efficient or sometimes inefficient players were running. So my sense would be, the first thing is, as the profession, we need to look and see what activities do we do that actually bring value, tangible value, and what activities do we do that we are really ticking the boxes. So if we were to assign and say, okay, so it always comes down to the money. So say your rate is 2,000 rands an hour, and if you are spending 2 hours a day filing, so okay, maybe you'll get legal aid or whatever, but ultimately it's 4,000 rands that you're spending on filing, when if you had applied a system, you could find yourself saving that money or saving your own cost to focus on other aspects where your time could be better spent. So it's really about seeing the value in the activities that we do as the legal fraternity. What actually brings value for us as an organization, for our clients, and what things do we need to push backwards so that we can focus on the core or the high value activities. And I think the first part around automation and bringing tech should be to say, let's create space for ourselves so that we can focus on the high value activities. And that mindset, I think, is what we need to be looking at, to open and to read and to accept those that sort of input. And then I think we'll start to change our minds around technology. It's just like how people started adopting the phones. At some point, people thought, no, this cell phone is bad, and people wouldn't put it to their ear because they're worried about radiation. But 20 years down or 30 years down the line, it's a totally different case. So I think it's things like that that we can consider to.
Thank you for that, Daniel and Ivan, for the question. What I'm going to do, I see someone has a very lovely point here, Asha, and she's suggesting that maybe we must arrange a session with Daniel to just talk about all the options that are available. Maybe that's how, to answer your question as well, Babu Gambonan, maybe that's how we'll start, influencing as well our colleagues in that regard. And I think the point he makes is very important when he talks about, what do you call it? The time value of money, a cost benefit analysis from a time point of view. Because, colleagues, that the other day I had a question that arose in my mind. And the question was that you have the CSD currently, right? Which is an absolutely fabulous system, eh? I think the CSD is one of the stories that we should be talking about in terms of successes. But then you have panels of attorneys that are being advertised every other day. And you then have to respond to those panels. I think if I can just give you an example, in the past 2 weeks, we've probably submitted applications to about 4 or 5 panels, right? This is in 2 weeks. But guess what? Those panels want exactly the information that is on the CSD, right? And that information on the CSD is actually approved and vetted by the system and the CSD, but you still have to submit that information to the panel you're applying for. In other words, develop paper, and then I then try to quantify how much it costs per application, right? Per submission that you make. And the cost was quite staggering to me. The cost was about 1,500 per application for a panel, right? Now, if we've done 5 panel applications in the past, or 2 weeks, it means we've already spent almost in excess or just under 10,000 rands already, just in 2 weeks of filling in panels. So those are the kind of things I think, tech has to talk to in the long term. So now, if you are a lawyer and you are billing 2,500 rands per hour, and let's assume that you are a startup attorney, you don't have, staff and those kind of people to help you with. And your average time cost to fill in that application is about 3 hours, just to finalize the whole application process. So your fixed costs are your printing, your driver to deliver the paper. Then, of course, you've got your time cost, which is somebody sitting there and doing the work. And if you are going to do it yourself at 2,500 per hour, it means on average you're spending, almost 8,000. Or even 10,000 per application that you're doing, spending your time on your rate. So those are serious, I think, tech challenges that, I guess over time we will have to learn to circumvent. Okay, Daniel, thank you for that. As you said, you're going to stay on. I want us to step off the issue of tech for now, and maybe just I want to ask the Solicitor General to please, give us his presentation. And once again, sir, thank you very much. I'm very excited to have you here. And I'm also happy. In fact, one of the things you mentioned when I was, in touch with you for the webinar was the issue of stakeholder engagements, which is basically part of what we're doing today. So welcome again to your new position, and welcome to being here with us today. And please, the stage is yours. You have 30 minutes to give a presentation. You're not married to it. If it's less, it's okay still. But of course, we will engage further as we proceed. Mr. Pandelani, the Solicitor General, welcome, sir. You may proceed with your presentation.
Thank you very much, Mr. Mkhwanazi. Thank you, colleagues, and everybody else that is in this platform. Thank you for giving me this opportunity to participate with you. It gives me singular pleasure to be here. Your kind words, in fact, were humbling. But yeah, let's get on with the work. Colleagues, I've been requested to join in today's webinar Most probably, most of you, like Mr. Mkhwanazi has admitted, didn't know about the existence of the position of Solicitor General, and that is understandable. The office of the Solicitor General, and the incumbent being myself, having been appointed on the 16th of March, 2 days before the first proclamation of the disaster management regulations in relation to COVID, is a creature of statute, meaning that whatever we can do, we do in terms of the provisions of the Act. As you would appreciate, the Act, in terms of which I'm appointed, is a 2014 Act. And the question that arises is what happened between 2014 and now. It's almost 6 years since the Act was passed in Parliament. And the President only proclaimed the coming into effect of the Act on the 7th of February this year, which ushered in the appointment of the Solicitor General on an acting capacity. And the question is, why acting? There are quite a number of challenges. The last time that the State Attorneys Act was promulgated was 1957. There's not been any amendment in terms of that Act. The amendments that were there were cosmetic in nature. They sought to take into account the various Bantu stands that were there to incorporate them. The first ever change that has been ushered in would be in terms of the Act that introduces my office. Now, being a creature of statute means that there are certain challenges that one might have to deal with. And one of the issues in terms of my mandate is to limit the contingent liability bill. As you would know, the state is one of the major consumers of legal services. At times it is circumstantial. It is not something that the state wakes up one day and say they want to litigate. And the question is, what should happen in that space? You previously only had one state attorney for the whole of the Republic. You now, in terms of the new Act, have 13 offices. And those 13 offices would be Johannesburg, it will be Pretoria, it will be Western Cape, it will be KZN, Bloemfontein. You've got 3 in the Eastern Cape, Mthatha, PE, and East London. You've got 1 in the Northern Cape. You also have a new court in Mpumalanga, which has ushered in the opening of another office of state attorney. You also have 2 in Limpopo, which is 1 in Polokwane and the other one in Thohoyandou. And so all offices or all high courts in South Africa are attached to an office of a state attorney, all of which have got heads of offices, as opposed to one office that was there and the others were branch offices. Now, why do you need a Solicitor General? You need a Solicitor General to operate as an executive of all those offices of state attorney. Essentially, like Mr. Mkhwanazi has indicated, is more like being thrown into the deep end. Deep end akin to you being parachuted to save an aeroplane that is in turmoil, but it's already airborne. You either will perish with all the occupants of that aeroplane, or alternatively, you can actually bring all of them in a safe landing space, which is probably what my role entails, ensuring that the state attorney model is saved, but delivers the kind of service to the state that is acceptable. There is another dimension to the Act, the new Act. Its focal point is no longer government, as you traditionally would understand it. Its focal point is the state. And by definition, the state entails municipalities. It entails provincial governments. It entails national government and the presidency. By extension, it also entails agencies and SOEs. And the question that arises is, if my mandate is to try and limit the contingent liability on behalf of the state, as well as reducing the state liability bill that is ballooning year in, year out, and with the reported problems besieging the offices of the state attorney, how do you then expand on the mandate of legal services provision? What mechanisms are supposed to be put in place to ensure that indeed there will still be legal services delivery? What mechanisms and systems are you going to put in place to make sure that there is a seamless communication between all these offices of state attorney? The other issue that should be interesting to all colleagues that are on this platform is the fact that Section 3, subsection 4 of the Act enjoins my office in a mandatory manner to come up with policies that should in fact deal with some of the challenges that were there. And fundamentally, it says that I need to be responsible for the coordination and management of all litigation in which the state is involved. And if you accept that the state is not national government, then you would realize that more needs to be done. All of you who are in private practice must in fact rally around and say, this is a very bigger mandate. What it is that we individually and collectively could do to assist the realization of some of the goals that are there in the State Attorneys Amendment Act. It is also my duty to come up with a coherent strategy on briefing. And this is briefing not only of advocates, but legal practitioners as a whole. Having identified that the state is the biggest consumer of legal services, perhaps also followed by the Road Accident Fund, the question is, who are the beneficiaries? Who are in fact assisting in rendering those legal services? Quite apart from the enormous work that the state attorneys are required to render from time to time. Are we going to be able to do these things without the assistance of legal practitioners? And that includes yourselves. There is another policy that should be talking about outsourcing of legal work, appointment of correspondent attorneys. It is not envisaged that those correspondent attorneys will reside within the offices of the state attorney. It is intended that it is you that actually must up the game and say, we are available. Having listened to the changes that actually might have to be put in place with the new way in which we ought to be doing things, it means that if we don't revolutionize our practices, we might be left behind. We might not be able to actually come to the party and do that which is intended by the policies. Internally, there are also policies that I must come up with, which in fact deals with initiating and defending matters in which the state is involved. But what excites me more is the policy that says I must pilot a policy that deals with ADR, and that includes your mediation and arbitration. And there is a virtue in that policy. And the virtue is that when you talk about the first policy, for example, where I need to come up with a policy that talks to coordinating and managing all litigation in which the state is involved, but fundamentally also reduce the contingent liability of the state, you will then realize that something must give. And that something that should give is accommodated with the policy that deals with ADR. Now, most of you that are in practice will realize that invariably you are required, when you institute certain proceedings against certain organs of state, to first address a letter that is mandatory. A letter that notifies that you are intending to institute proceedings against certain organs of state. There is also an added issue there which says you cannot issue summons within a certain period of time. I sat and reflected on this aspect. As a practitioner myself, had asked the question as to what is this period that is there, which is said to be a cooling off period. What is it intended to achieve? Because you still wake up after that mandatory period and issue summons, and it appears that government departments and or those that are responsible are unable to even know that you have issued a letter of demand. Invariably, you are also asked to produce that letter that you might have served. That should be addressed. And the manner through which we address that might be tied back to the policy that talks about ADR. At a strategic level, my intention is to, in fact, have that act amended, extend slightly the period within which you need to give us notification, and you will be giving the Office of the Solicitor General, which is also required to act as executive of all offices of state attorney, the notification. But once you give us the notification, it triggers something. It will trigger from my office a request to you that is initiating the matter to agree to be subjected through the ADR process, which is mediation and arbitration. My view being that protracted finalization of matters should be avoided. And if we're going to avoid protracted finalization of the matter, my view further is that, if you get 100 Rand today, it's actually much better than getting 500 Rand in 7 years. But all of these issues will need warm bodies. And the state attorneys in their current state, whatever we do, might not be able to respond to the vision that my office has in dealing with some of these matters. The state litigation policy, which is one of the policies that we are in fact piloting, should also be based on the fact that the state government and its various organs and agencies, including SOEs, are predominant litigants in courts and tribunals. And my mandate in that regard is to transform that landscape. And when you transform that landscape, you need to take into account the fact that you need to have a responsive, efficient, and responsible litigant in the form of the state. Now, the terms that are virtually used, efficient and responsible, calls for resources. It calls for a realization that the state cannot actually just defend the matter just for the sake of defending the matter. There are certain matters that are actually not even worth defending. But at least at that early stage, if we have a policy that talks to those issues, we could be able to arrest many of them at the ADR process or stage, which is not court annexed. It will be an act of parliament if the Office of the Solicitor General were to have its way. And if it is an act of parliament, it means we cannot be clouding the courts with matters that could be resolved at an early stage. With the realization that the state does not have capacity, whether through the state attorney's model or otherwise, and the various government departments all having chief directorates dealing with legal matters. The question is, who are you briefing to assist you? And so if you look into this space, my office will be issuing out a request for expression of interest by legal practitioners so that we can have a database that responds to some of the issues that are violated. And in doing so, we will then have to flatten the manner with which briefing and briefing patterns are done and conducted. We cannot be seen to be complaining going forward. And for that reason, it is mandatory on my office, if not instructive, that I need to engage all stakeholders. And this is one platform which enables me to indicate that we need to engage all stakeholders in all the policies that my office is going to pilot. It is envisaged that those policies must be approved by Cabinet and should be tabled in Parliament. And for that reason, it is essential that all stakeholders, including practitioners, organized formations, will be given an opportunity to make comments and inputs. And you cannot be heard to complain once those policies have been given to Parliament to approve, or for tabling, or given to Cabinet to approve, and finally to Parliament. And fundamentally, all the directives that will be issued by my office in relation to those policies will also have to go to Parliament. It's not an arduous process. The policies are already in draft form. We don't have much time, meaning by the 31st of October, which is my deadline, I need to have received inputs from all of you. I think in this stage of the pandemic, what we need to be talking about is not only the adage of saying we need to flatten the curve. I think we need to bend it. And bend it in the sense that there are people, there are practitioners that have been there for a very long time that are good in patents, designs, copyrights, and the whole of other competencies. Other people have got specialized skills, have actually established their own practices, but when they go knocking at the door of various government departments for work, they soon realize that it is not going to be possible. It is not to be unheard of for somebody that in fact has a master's in corporate work, who has not actually touched any work that resonates with whatever they've done at varsity. I think we need to change that landscape. But we can only change that landscape if there are willing participants. And those willing participants are collectively yourselves and the other colleagues that might not be on this platform. In the short space of time that I've been here, and with the few policies that I've actually tried to communicate to the colleagues in the state attorney model, and more particularly in relation to, and this is just an indication because I need to ensure that all government prescripts are dealt with. Just to give an indication of what the strategic vision is. Just for July alone, if you talk about briefing and briefing patterns, and with the kind of observations that I've made, our rate of briefs to PDIs only for the month of July will be sitting at 83%. The amounts that have been confirmed to be payable to those practitioners would amount to about 669,984 million rand. And that's just for 1 month. Now, if you don't come up with intervention mechanisms, something that disrupts something that has been there for a very long time, you are not going to be able to reach those figures. There should be a realization that black practitioners also should be given quality briefs, not quantity. Because if I were to show you a group of black practitioners that are there that have been briefed, and you say, what was your spend? Your spend was 1 million rand, but amongst them, in the majority, they've only shared perhaps 5%. There's much to be desired there. The policies themselves are not going to be discriminatory, but they must actually take into cognizance the fact that things are not as normal as they ought to have been. And in fact, we are lagging behind time in order to flatten the manner with which government deals with this issue. I actually would not be surprised to find that from time to time, all of you have been running to the various government departments for work, without any follow-up, you would be surprised that you are actually not being accorded that space. The Act and my office being a creature of statute means I need to then make those unfavorable sounds and ensure that anything that sounds in legal work cannot be warehoused under some other guise in order to be given to those who are preferred to be given that work. What it says is that difficult decisions will have to be difficult decisions. I actually am also aware that I'm not in this space to make friends, but I'm also not a career civil servant. And my colleagues are fully aware of the fact that I'm not a career civil servant. But it gives me a better perspective coming from outside, because my thinking probably would have been different had I been in government for the past 20 years. Because where a window is broken, you end up actually appreciating that you've been living with that window for the past 20 years and no one has complained. But when you've got an outsider, he's at liberty to tell you that that window is broken and it needs to be fixed. And the fixing part of it is a resource tool. And so having policies might not necessarily translate to having the resources. But it is important that when those policies are there, when the database is created for all of you, I also need to monitor who from that database is actually getting instructions. It's quite easy, as we have observed, even during my time in practice, that you could actually be a preferred bidder in a way, and you stay in that database until the period ends without actually having any brief whatsoever. You just go there as a decorative. But I think with all that knowledge, that is something that we might have to avoid. When I referred to the issue of responsible litigation, I mean responsible litigation in the sense that it is not all those matters that actually must be going to court. We should actually have a way in which we deal with some of the issues even before these matters serve in court. Just taking a matter to court or taking government to court takes a lot of money from anybody else. And I think it is not a foreign subject to hear somebody telling you when you are threatening to sue to say, well, you can go ahead and sue. Government cannot run out of money. My mandate says that the usage of that statement should be proscribed. It should be eschewed. It cannot be countenanced. We need to be a responsible government, and being a responsible government from a litigation point of view says that we also need to be responsive to the needs of those that probably see something wrong with government, whether it sounds legally or otherwise. And that responsiveness, insofar as legal matters is concerned, vests in the office of the Solicitor General, and I'm the incumbent in that office. There are quite a number of issues that we can cover, but I can actually deal with all the other issues on the question and answer session, Mr. Mkhwanazi. Thank you. Mr. Mkhwanazi?
Mr. Mkhwanazi, you are on mute. Mr. Mkhwanazi, you are on mute.
Maybe Professor continue talking again.
I think you can continue. It appears Mr. Mkhwanazi was disconnected and will log in shortly.
All right, no, that's fine. I'm prepared to take questions if there are any questions. I think the talking points are quite a lot. It probably might need a full day seminar if we were to unpack each and every aspect, more particularly in relation to the policies that we need to pilot via the Office of the Solicitor General, and extensively the mandate that in fact I need to fulfill. So colleagues that are in the platform, I'm available for taking any specific questions so that we can deal with them.
Yes, sir. So usually how we do it is we have folks sending in questions on the chat, or they can raise their hand. I see Ivan has raised his hand rather, and I'm going to ask Ivan to please unmute himself and proceed to ask the question.
Thank you very much for the opportunity, and thanks, Solicitor General, for sharing us your views, particularly about your appointment and the challenges indirectly that you have shared with us, and the fact that we're dealing with an old act here of 1957, and there's a new act of 1914. It was promulgated this year. We appreciate that, and you have indeed shared various perspectives with us. But my question really, Solicitor General, centers around my observation, as I'm saying that I'm in practice, and I've been in practice for the past 16, 17 years now. And what I have observed with the Office of the State Attorney for the past years, when it comes to attorneys, they only work, or rather, the work that we access as attorneys is to be used as correspondent. But a lot of substantive work goes to advocate. And I also appreciate that it makes sense for an attorney to brief an advocate. It doesn't make sense for an attorney to brief an attorney. So the Office of the State Attorney has been arguing that we are attorneys and we can only brief advocates, we can't brief attorneys, you know. But my concern is that all of us now are legal practitioners, you know. And I must say that I have been in court on several occasions. I've seen a lot of advocates not having a clue. Some of them leaving submissions, leaving a lot of things in the hands of the court. Some of them, we've seen judges being irritated with advocates that are not prepared. And you will find that also most of these advocates are moving papers that are prepared by us attorneys. And the Solicitor General, I've been also in court. I appeared on various occasions in the High Court. Sometimes I realize that judges use different method of adjudicating matters. I've seen instances where judges would say to advocates, I have read the papers, please address me only on this and this aspect. And this tells me that in most instances, you will find that a matter is won on the basis of the papers. And in most instances, you will find that by the time the judges come to court, they've made up their mind. It's just that they would want the advocates to address them on various aspects. Now, I was just laying a basis for my question. My question is, why are you not giving us attorneys work? Because all of us are legal practitioners. All of us have the very same LLB degree. And I do appreciate, Solicitor General, that we attorneys are more trained in terms of preparing matters, and then when they are ripe, we'll give them to advocate to appear in court. I appreciate the fact that the advocates are trained more in advocacy and so forth. I appreciate their unique skill in terms of being persuasive, in terms of presenting a matter in a particular manner that will persuade a judge to rule in your favor. But I am saying, Solicitor General, why the Office of the State Attorney does not view us as practitioners, all of us, and they create a database of everyone who is practicing law, and they not brief, they give work to all of us on the basis of our abilities, not on the basis of saying that this is an advocate, this is an attorney, because you know you have been in practice for more than 20 years. You have probably come across advocates that have disappointed you. You have come across good advocates. You have come across good attorneys. There are a lot of attorneys that are litigating in the High Court. So I'm raising this because we are seeing a lot of attorneys leaving the profession, not because they don't have abilities, but because they don't have access to work. And the state is a consumer of these services. We would expect the state to support us as attorneys so that we stay in the profession. We don't leave the profession. Thank you very much.
Okay, thank you very much for that, Kambonani. Sorry, colleagues, I got frozen out from my initial session, but I've logged on another device, which also seems to be much clearer. So thank you very much for that, Kambonani, and also Solicitor General. Thank you very much for your presentation. You really blew me away in terms of what your office has to achieve, the tasks before you. In terms of the opportunities that are on the horizon insofar as legal practitioners are concerned, and you also mentioned that I think you said only for July 2020 you spent about 669 million on fees for PDIs. And that is going to basically come back to the issue of costs that you referred to, in your discussion. Colleagues, before I open the floor, I just want to check with Dineo if she is available, because you remember we have on our invite, but unfortunately she's out of town and she mentioned that she's got connectivity issues there. I would have loved to hear something from her before we lose her completely. Dineo, are you online? Are you able to talk to us?
I'm able to talk to you. Can you hear me?
Okay, that's good.
Hi, Renee.
It appears we lost Mr. Mkhonazi, but you can proceed to share with us. Dineo?
Yes, I'm here. Can you hear me?
Yes, ma'am. It appears we lost Mr. Mkhonazi, but you're welcome to proceed.
Okay. So, Mr. Mkhonazi requested that I speak to the challenges of practitioners, particularly during the infancy of the practice. And I'd really say that there are internal and external factors, internal being yourself and how you yourself run the practice, and external being factors that you don't necessarily have an influence on, but impact your business. And I'd say internal factors that or challenges that I would say when I in retrospect, when I look back, was sort of challenges that we kind of imposed ourselves. One, in not having appropriate operating systems in place. For instance, having sound financial management systems in place and sound human resources management systems in place. You kind of want to do everything manually. Secondly, you want to do everything yourself, and you realize that you can't do everything yourself. And that's where the distinction comes in between being a business owner and being self-employed, because your practice needs to get to a point where even if you remove yourself, it's able to run efficiently. So we now try and within operating our practices is we try and do everything ourselves. And in the end, certain aspects of the business stuff. And I'll give you an example, something as simple as marketing. Knowing very well that you're a lawyer and you're not a marketing aspect. Yes, you could put measures in place and have activities that you yourself could implement to be able to effect marketing. But I think for the level with which you want to go and the efficiency at which you want it to happen, it sometimes assists to capacitate to not capacitate, but to outsource certain functions within the business. Secondly, is the issue of capacity. Again, we come as lawyers with different fields of expertise, and yet we kind of want to operate in silos. So if I can give an example, you'll find a tender that requires 12 practice areas, and your strength is only in the 3. And because you're operating in silo and you don't have partners or association agreements to support the areas of a business that are lacking, you then lose out. One, to the organization that you're bidding to, you want to come across as a jack of all trades. But 2, it kind of displays a lack of inefficiency as well, and questions one's capabilities to be able to deliver if one is awarded. So those were for me what I could say sticks out as the internal challenges that we kind of impose on ourselves, or things we don't look out for. There are, however, external factors like historic barriers to entry. So I, by profession, am a mining lawyer, which is a very white male-dominated industry. And when I was in corporate working for a multinational mining company and heading the legal division, I was recognized. However, the moment I stepped down, or not stepped down, I removed and I changed roles to be a mining lawyer running a practice as opposed to an employee, and now having to compete with the big 5, which are those, there are other smaller mining law firms, but having to compete in niche in a niche sector, you do have those historic barriers to entry. On myself, I think I felt as an attorney, but 2 as a female black attorney, and I think I think it's gonna take a while to remove those barriers, but I think we also have a duty upon ourselves to capacitate ourselves and be persistent in terms of how we capacitate and how we seek to enter a niche markets. And a further challenge that I experienced in running practices is effective implementation of transformation legislation and also policies. And it was so welcoming to hear from the Solicitor General the measures that he will be taking in place, and the concern the volume and the budget, the quantum of work in monetary terms that goes to historically advantaged firms versus HDSA firms, and it's really great. You know, I'm really seeing changes in how our government is moving in terms of putting resources like Mr. Pandalane or officials like Mr. Pandalane rather at such a critical institutions, and it's so reassuring to hear what his plans are within his office. And lastly, a further challenge that I think we as lawyers suffer from, particularly those of us that are new into running practices, is appropriate skills. And I think we need to capacitate our skills to be able to deliver to the standard required. And I think that the service, as Mr. Gambanane quite correctly pointed out, you get highly.
Okay, colleagues, it appears Dineo caught my bag as well.
However, work goes to people that either have always been receiving work and are.
Okay, Dineo, I think we keep getting cut. I'm going to ask maybe that, we proceed, whilst you're trying to improve your connectivity there. But anyway, we will also obviously have questions and inputs on Dineo's discussion, colleagues. But I also want us to, of course, the Solicitor General said a lot of profound, important things. And I would like to open up the floor now to questions so that we can all benefit from his presence here today. I think Kambonani, you already raised something. Can I also maybe add two questions to those? And colleagues, please get yourself ready with your questions. The first one is that I heard about 3 years ago, when there was the first time that the spend on legal services, by the Department of Justice came to the public attention. And if I recall, this amount of 669 million was an amount that was spent in one financial year. So it was almost $1 billion. In fact, I remember it was 900 million or so, which was spent in one financial year only on legal services, and for a year. So here you're saying this amount was only paid in 1 month. So what is your, overall, budget for legal services as the state, I suppose, as all of these entities fall over you per annum, where we're sitting currently? And then the second issue that also I think Dineo was touching on is the issue around transformation, that, all the transformational ideas and ideals we have do not seem to take traction. Is there a BEE, legal a charter, an industry charter for legal services? I remember many years ago I heard it being touted, but I'm not sure what the status of it is now. Is it there? Is it not there? What are we going to do about that? Can you please, Solicitor General, respond on the 3 questions in the meanwhile? We've also received some questions on the chat, so when you're done with these 3, I will get back and add the others that have been asked on the chat. Thank you once again, sir.
Thank you, Mr. Mkonazi. I think let's correct the figure that you actually had. Yeah. I think it was at the time when you were getting disconnected.
Okay, great. Okay.
I only extrapolated a figure just to demonstrate the changes that are happening in the briefing landscape. And that figure, it's just under short of 70 million rand. It's only for July, and also accept the fact that we are operating under difficult circumstances where legal practice is not as we know or understand it. But even under those difficult circumstances, what I was trying to demonstrate is that if you've got responsive intervention mechanisms, you can in fact flatten this landscape. If you were to say most of the briefs in that 70 million were valuable briefs, and the quantum of the amount translates to 83% that has been spent on PDIs, then we should be on the right, we are on the right track insofar as dealing with some of the issues is concerned as a policy. And also, this is happening under circumstances where the policies that are virtually indicated have not actually been ratified by Cabinet. These are interventions that are, in fact, being made even before we reach the promised land, if there is going to be a promised land from a practice point of view. And so I'm hoping that we could actually be able to keep the trend, because we do, as a department, have policies that guide transformation, and that goes to your other question. BEE, it might not be a policy that actually talks out of what is available, that which national government, in fact, subscribes to. I do not have piloting a fresh BEE policy from my office. However, in whatever I do, I need to follow all the treasury prescripts that are in place, those BEE scorecards that are there are also applicable to legal services provision. Going back to Mr. Kambonani's initial question, why there is discrimination insofar as briefing by state attorneys is concerned. You only can get a benefit if perhaps you are acting as a correspondent of the state attorney, and you can never be briefed to do the kind of work that advocates do. I think my answer to that will be multifaceted. Multifaceted on the basis that we need to be cognizant of the fact that there is the Legal Practice Council. The Legal Practice Council recognizes legal practitioners. They could be traditionally those who were advocates, and again, they could be those who were attorneys. There are also other people in between there, advocates that are now seeking to open trust accounts, but all of them are legal practitioners. However, having indicated my intention of having a database, that database will in fact require of practitioners to indicate their skill set. If you do have rights of appearances at the High Court, there should be and ought not to be anything that precludes our office or the offices of state attorney from briefing that particular person. You cannot be displaced or dislodged to go to the other side and be an advocate merely because you want to get instructions. Instructions should be based on competencies of that particular individual, irrespective of the tag that is associated with that person. But you also will be cognizant, Mr. Kambonani, of the other issues that we are piloting with the Legal Practice Council, which seeks to recognize lawyers in the category of skills. So where you would have a senior counsel, for example, there will always be an alternative to senior counsel who chose, for various other reasons, not to join the bar when it was, or when it could have been fashionable to do so, but remained on what colloquially was called a sidebar for some other reason. And you will then be called a senior attorney. Now, senior attorney in status, in terms of the codes that are going to go out, would be a person who ordinarily is akin to the status of a senior counsel, given the experience and the road that that person has walked in practicing law. And when it comes to briefing, we cannot now try to segment those skills and say, now you are an attorney, we are not going to give you brief. There are attorneys that are very knowledgeable in matters such as you've identified, whether it's intellectual property or otherwise, that could actually stand before any other judge and argue those matters in a more meaningful manner. There are a lot of attorneys that are practitioners in environmental law, for example. And it cannot be that when we brief you as an expert in environmental law, mining law, and you have demonstrated that we can see from your database that you say you possess these skills, that we will start discriminating against you. So it is a valuable point that you make, a point that I'm also cognizant of, and a point that we need to also inculcate when we come up with the final list of those who are on the database, but also not have a database for the sake of just having a database, but have a database that is interrogated from time to time, so that we then are able to say who from that database has been briefed, who from that database is being briefed the most, and why. Are there any empowerment mechanisms that are in place? And Dineo speaks about practitioners operating in silos. This is an issue that is of serious concern to me, because my view is that in each and every loaf of bread, there is a slice of bread. And it is time that legal practitioners must actually start having multidisciplinary practices within themselves, so that when work is in fact given to that law firm, it is a one-stop firm. Where you are not possessed of the kind of skills, of course it is understandable. But a situation where we've got mushrooming black law firms, single practitioners, all of them queuing at the courts, competing with those that are briefed by the Legal Aid Board of South Africa, where I also sit as a board member. You know, for what? We need to be multi-skilled. We need to actually take advantage and attend other courses. Lawyers should be self-taught in other instances, but attending courses that progresses your knowledge of the law is also fundamental, because we are limiting ourselves. We are not actually taking advantage of work that we previously have said has been reserved for certain categories of people. We are in a unitary state, and being in a unitary state means we need to take care of each other. And taking care of each other means that from where I sit, I need to look and zoom into the space where legal practitioners are and say, what are the limitations? Why aren't you getting work? Why aren't you checking yourself, polishing yourself and saying, look, I can do this work? Of course, there is no one repository for skills. If you would have seen currently with the COVID-related matters, and when I got appointed, one of the other difficult issues was to issue a directive that seeks to say all COVID-related matters should be centralized in my office. And there's a reason why I did that. Because I needed to monitor the briefing patterns. Now, invariably, you are going to be told that that so-and-so does not have skills. But how do you get skills if you are not given an opportunity? Is there anything wrong with the state saying we are going to disrupt this space? We are instructing you as senior counsel to deal with these matters. But would you mind, and this is a request from client, and I'm a representative of client. I'm not the Solicitor General for the Department of Justice. I am for the entire country. it is incumbent on me to, in fact, seek those interventions and say, I understand there is this counsel that probably possesses these skills. He might not be as polished as perhaps one person that would stand on his own and get those instructions. You are going to include this person in your team. And by doing so, you are also making sure that that particular person benefits from skills transfer. There is no one person that would actually want to be a brief carrier forever. And of course, if we are watching you, we've given you a brief, we've put you on a team that actually had to deal with matters. The next time we come to you and say, but we twinned you with people that had the skill space. Mm-hmm. Now, can you stand on your own? And those are the kind of interventions that all of us need to think about, including attorneys. Thank you, Mr. Mkotas.
All right, thank you so much, Solicitor General, for that input. I think for me, there are some questions here. The first question is from Asha, who was asking if we can canvass you to check if there's a possibility of having sessions in every province for the envisaged policies. You will tell us your view on that, SG. And then, of course, there's a question from Mr. Mishak Malaudzi, who's asking here, what are the challenges that the Solicitor General is experiencing in transforming the state's litigation strategy? My question would actually be, is there a strategy currently? I mean, just to add to Mr. Malauzi's question there. But the third one, Solicitor General, whilst my colleagues are also wrapping their thoughts around theirs, is this. There's this issue about letters of support, or commendation letters that you need to submit when you apply to be on a panel. This requirement, I've seen it proliferate over the past few months. But the problem I have with it is that there seems to be different rules on what this letter should be or should have, right? So you will have a situation where they want a letter for a specific, practice area. So in other words, if your firm has 15 practice areas, you must get 15 letters for each and every one of those practice areas. And then in some instances, they say, just give us a letter from your previous clients. That is very frustrating for most of the practices, I can imagine. But you will talk to that in your response as well. Maybe you can take the ones I just asked you, and then we'll wait for further questions. Colleagues, any questions? But please, in the interim, SG, you can respond to what we've just mentioned to you.
Yeah, I think the raise that Asha raises is very important to the work that I do. I've got very strict deadline, and I've already indicated that I'm not a career politician.
Yes.
Or civil servant, as it were. I'm not actually there to work for notches in year one and probably pilot one policy 1 year so that you can actually have some brownie points.
Yeah, I think you have 2 years. Am I correct? You've been appointed for 2 years?
Yes.
Okay. Yes. Okay. Thank you.
And 6 months of that 2 years is gone, by the way.
My goodness.
Yeah, so time flies. We will see what develops. And so I'm amenable. We are operating under difficult circumstances.
Yes. Okay, great stuff.
One of my, 2 days after I was appointed, the first thing that one needed to do was to start assisting in the drafting of the disaster management regulations. So you can see get distracted in some of the other things. And I'm saying my key deliverables are what is contained in the Act, what is contained in the performance agreement with the minister, who is my principal, who himself is a lawyer and understands some of the problems that we sit here. I don't have to write lengthy memorandum to explain myself. He knows these things. I know these things. I've played in these streets for a very long time myself. And sometimes you need to develop street smart credos to survive. At the risk of alienating some of the people that might be in this platform for other reasons, but being colleagues, I think I might have to zoom into Mr. Mlauzi's question. I think it is a good question on many scores. And I think he is in fact asking it, knowing fully well that the answer to that question might ruffle some feathers, but of course, we are not here to make friends. Mr. Mnauzi is a lawyer.
Yes.
And as what are the challenges that I'm encountering in transforming the landscape? The challenges are enormous, as it is to be expected. This is not a privately owned entity. This is an entity, or it's our government that in fact needs to pilot these aspects. But one takes umbrage on the fact that from time to time you need to sense whether there is support of what you do. And I can actually say to Mr. Mnauzi, on the 5th of August 2020, a full cabinet approved my vision. A full cabinet indicated that I need to implement the kind of things that I've touched on with you here. It takes longer in this space to have certain things approved. We've been writing some of these things from the time when I was appointed, outlining the vision of the Solicitor General, looking at the best practices. In other countries, the Solicitor General is a member of cabinet. We are happy that I could walk this route with the executive authority, who is the Minister of Justice, because that is where the office finds shelter in. There are challenges, and the challenges that one could talk to would be resistance to change, number one. And resistance to change is by those who would have a vested interest on the status quo. Those who have got a vested interest in the status quo would be those that realize that the powers that are now bestowed on the office of the Solicitor General are powers that traditionally were their powers. And you would ordinarily expect that there will be people that would want to dislodge whatever you are in fact wanting to do. There are other challenges in the sense that from where I sit, the 2 years that Mr. Mkhwanazi you see has got a purpose to it. The question was whether you make an appointment fully fledged, a 5-year renewable process where there is nothing. I don't step in the shoes of any predecessor. I need to be making my own mark with the people that actually are earmarked to support me. One of the other problems that you would actually have is that you cannot go there immediately and create a structure, because a structure needs to be informed by strategy. And when you now need to develop a strategy, the question is, you walk there alone. You must actually identify suitably qualified candidates that would be able to say, this is the overall strategy. The strategy of the Office of the Solicitor General is not the strategy of the Department of Justice. They could resonate with each other. However, that functionality and problems that were inherent previously in legal services provision, and also making sure that the state is well defended in matters, but those matters that actually do not require to be defended are resolved in a manner that in fact is humane, in a manner that says you are not going to waste state's resources. Now, resource also might actually be a challenge. And that challenge is not one that is insurmountable, because the unit that I'm heading now has got added powers. It says, in terms of the approved plan, I need to have a unit that deals with management of all contracts and commercial agreements in which the state is involved. Now, fundamentally, that goes back to Mishak's question, that if you are going to have oversight on contracts, and those contracts will relate to some of your SOEs, and you are going to have oversight, it's a problem. So it comes with enormous problems in that regard, because there are people with vested interest in what has been happening in that space. There is another point there. With the database that I'm going to create, and it is incumbent on my office to intervene in all manner of litigation. Because where I suspect there is a phony litigation that is going on, my mandate is to go and join in as a third party. Now, you are a disruptor, because if it's a phony matter, you are entitled to see all documents that are exchanged by and between the parties. And if it is as phony as you would suspect, that is the end of the matter. The question is, do you have the resources to be able to do that? I don't. I should be able to say from the legal practitioners, we are giving you a brief, you are going to join in this matter on behalf of the state, just to be that fly on the wall, because we want to see what is happening. And that is why I'm saying all of you must actually seize the opportunity, respond meaningfully, because it is not the database that is going to decorate some office somewhere. It is a database that actually should be used as the eyes and ears of the Office of the Solicitor General. The state attorneys are already flat as it is. I usually use an example of saying, more often than not, they get blamed for starting the fire, when in fact, all that they are doing is to fan or stop that fire, not starting it. State attorneys do not wake up and say, look, let's go to litigation. They represent client departments. But those client departments, once the policies are in place, the landscape is going to be far-reaching. Because if I were to give you an example, Mr. Mkwanazi, I could wake up tomorrow, there is a unit that deals with management of contracts, and say X and Y are concluding an agreement, commercial agreement. You are given a brief to go and observe and also ensure that that contract is lodged with the office. So it's enormous. It's something that would give you sleepless nights. And the question that Mr. Mlauzi would be asking would then relate to, as at the time when you then create that structure, how will it look? Because it is one of my mandates, that that office should be fully fledged. It should have what you traditionally would call management of state litigation, which is traditionally what state attorneys are doing. But it must also deal with constitutional litigation. There is nowhere where constitutional litigation on behalf of the state is residing. It now resides in the office of the Solicitor General. There is nowhere where management of contracts in which the state is involved resides. It will reside in the office of the Solicitor General. So there are quite a number of opportunities from that perspective. There are other competencies that, in fact, we can deal with as we go along, but the mandatory policies that you have referred to, that Asha had asked whether one could actually form, I view this as a national duty. And if it is that we are going to have provincial consultative meetings, it makes sense that at least all stakeholders, interested and affected parties, are given an opportunity to make comments and inputs. This is not a personal project. This is a project for all of you, because I'm still representative of all of you. I still have my Fidelity Fund certificate and will have it for as long as I hold this office, because it is a requirement of that act. And therefore, there can't be any element of arrogancy in what you do, because you are doing this for the common good. You are doing this for everybody else that actually seeks to practice the law. But fundamentally, we need to flatten the curve. Thank you.
Thank you so much, Mr. Mlawitzi. I'm sorry, Mr. Pandelani. We have colleagues 9 minutes remaining. I have one more question, and I have Matsiho. Her hands has been up for a while. Matsiho, are you there still?
Yes, I am here. Thank you, Mr.
Oh, welcome. Thank you, Matsiho. You may ask your question.
Yes, thank you, Solicitor General, for making time to open our eyes on what your intentions are. They are very good intentions. I actually found it curious that your position was advertised as an acting position. And the question that came to mind is, who is actually the incumbent if you come in as an acting Solicitor General? Maybe just let me start off by just some prefatory remarks to say that in your explanation, you mentioned, amongst others, that whatever you do would be in accordance with the Treasury prescripts. And what I can just highlight to you is that the triple PFA itself undermines the redress of the past. And it is something that requires attention. When I was on the BEE Council, we tried hard to call for the overhauling of that legislation, but there is resistance, and from my observation, it seems the resistance is from Treasury. So it is one other thing that needs to be attended. Now, the other thing that also bedevils the issue of Black economic empowerment is the tender requirements. Mr. Mkwanazi has already touched on some of them, like the letters, the reference letters that are being requested, but also you find the request for a proof of experience and so forth. So I am actually excited that in your address, you have shown that you understand these obstacles, and in your developing the policies on briefing patterns, you will take care of that and make sure that people are not unnecessarily discriminated against. Now, because if you don't do that, you end up having people, acting in an improper manner, securing letters from some quarters, and once they do that, then there's going to be a narrative that blacks are corrupt. Blacks are bringing in fraudulent letters and so forth and so forth. So let us try to make sure that whatever we bring in does not perpetuate that narrative of blacks being corrupt. Now, I think it's Peter. She mentioned the issue of us having to capacitate ourselves. What I can say is that if there are any people that have really gone out of their way to capacitate themselves, it's blacks. Most of the black lawyers, they are actually overqualified. And what has driven them to be overqualified is that quest of trying to get recognition, that quest of trying to gain access to that corporate work. Notwithstanding those qualifications, they are still not getting work. So it has to be clear that blacks do understand that they have to be capacitated, they have to be empowered, and there is no one who is trying to look for work that he does not understand. An issue of skills. I mean, where do you get skills from? If you don't get exposure, where do you get them from? Do you still go back to class and get taught and go back and sit down with that? I mean, now in our days when we were trained, we were told lawyers are trained to know how to find the law and where to find the law. You give a lawyer anything, she runs with it. At the beginning, a lawyer may be slow because he's still trying to learn the ropes, but in a short space of time, that lawyer runs. You look, for an example, at our judges. There is no specialist judge. Judges do everything. Is there can we say there is something that suggests that they are incompetent? And my answer will be no, I don't see that. This issue of specialization and so forth has actually, I think it's sort of an inverted complex. Every black law firm now, whenever you talk to them, they'll say, no, we just doing commercial work. We are specialists, we are specialists, we are specialists. The very people that tell you that they are specialists, they say we want to become judges. And you say, but if this person says his brain has grown so narrow that he is now a specialist, what will he do? Is he going to be a learner judge or what? So I would like to say, really, let us not be too much in fashion and try to get those techs, taking all the time. You will know your competencies. Of course, I agree with the fact that, as highlighted by the Solicitor General, that the Solicitor General would like to get a one-stop shop where you understand or you have the competency. I mean, we also depend on others in the firm. So that mutual assistance resource will grow as and when people start getting decent work. Then they will be able to resource their offices accordingly. But now the question that I'd like to ask a Solicitor General relates to your scope. As you said right at the beginning, you are the Solicitor General for the state, not for the government. And now that means that you will be servicing the 3 tiers of state, or the 3 state, amongst others, the 3 tiers of government, which is national, provincial, as well as local. And also, you will be doing legal work or be in charge of legal work that also affects the SOEs. Now, in the recent, not even in the recent past, presently, one sees a proliferation of the invitations to bid for tender for legal or attorneys panels. Now the question is, once the policies that you are proposing are accepted by government or they are accepted by parliament, what is going to happen? Are you going to stay outside and remain with only work that was being done by the state attorney all along? Or would you be able to stretch your arm even to those that would have then established their panels? Thank you.
Wow. Thank you so much for such a, insightful input there. Certainly you raised a lot of issues which, in the back of my mind, some I'd forgotten. For example, the issue about, the triple PFA. And I think the PFMA itself, I've been one of the champions of a radical overhaul of the PFMA, because you'll recall, Solicitor General, that the PFMA came in at a time when the state wanted to cut costs because of the debts that were inherited from the apartheid government. But since then, we haven't gone back to say, is this still working for us? So the PFMA stifles people from spending rather than encouraging the state to procure services as much as possible. And that is an issue. The other thing around this issue as well is the issue of the terms of reference for this, panels of attorneys and all of that. Sometimes I see terms of reference and I know exactly who drafted them, right? So, for example, I once saw a panel of attorneys. I think it was the DBSA that advertised this. And I remember I objected to the deputy chairperson of the board at the time, because one of the requirements was that you must have won an award in property law for you to be on the panel. So are we going to see a change in terms of streamlining the requirements for this panel, so that we have, everybody knows what the game plan is? But whilst we are responding to Ms. Matsepe there, I'm sorry I don't know her surname. I would also like you to talk to one final point, which is someone asking, what are your support measures for newly formed firms? Are there any support measures for that? And sir, after you're done with that, I'm going to ask Mr. Kambonani to close the session for us, and then that will be the end of it. We are exactly on 6 o'clock, sir, so please indulge us for another 5 minutes just to close off, and then we can be able to shut down. Thank you, SC. You may proceed.
Thank you, Mr. Mpanazi. I think for some few minutes there, you were talking to yourself. I have been cut out. So it's fine. I think the Masiko that you are relating to is a senior colleague, Ms. Ramakaka. You probably will be fined for not recognizing some of our senior practitioners.
Guilty as charged, sir.
Yes, it's also pleasant to, in fact, know that some of our senior colleagues, in fact, appreciate some work that we could be doing and some challenges that could be there. I didn't hear the full question completely, but I think the first part that she referred to was the fact that the Treasury BEE prescripts are problematic, that they in fact are lacking in addressing some of the challenges that we might have been faced with. I think I concur with some of those aspects that she raised. I think that is a discussion that we might have to take forward, more particularly in relation to piloting the policies. It is not my intention that we should in fact have policies that will just be there on paper. It should be policies that are implementable and respond to the challenges that Black practitioners have been having all these years. A while back, it could be 20 years back, one of the colleagues in government had requested that we should get together to come up with a mechanism that responds to briefing patterns by government. We, with various stakeholders, laboriously set and detailed that document, our wish being that we needed to assist our government. I cannot tell you where that document ended up being. I've never seen it to this day. Now I'm on the other side. When that happened, I was on the streets or in the streets as a practitioner myself. And it gives me a perfect opportunity now that I'm on the other side to be able to appreciate some of the problems that are there on the ground and some of the issues that Ms. Ramakaka raised are very cogent and might need to be dealt with. But I think there's also another adage that says if you want to eat an elephant, you should actually be very meticulous on how you do it. You need to adopt a bit by bit process. I think the day that I go in there guns blazing, it goes back to Mr. Mlauzi's question to say what challenges are there, because you will soon realize that all doors are closed on you. People lose nothing. You might want to pilot the best crafted policies, but if you don't have buy-in by stakeholders who share in the vision that you have, you will achieve little, if anything. And one need to obviate having to, and I'm saying that obviation is circumstantial. It is circumstantial in the sense that where there are certain people that are responsible for certain policies, you need to have a gentle persuasion and not steamroll your own views on them. And of course, with all legal practitioners, organized, individual or otherwise, my undertaking is that there is no policy that is going to be tabled before cabinet without your inputs. There is no policy that is going to be going to parliament without the input of the practitioners, because all these policies, are, except for those that deal with administrative issues internally by state attorneys, the policies that seek to talk to you as stakeholders must also be informed by your own inputs. There will be gremlins, there will be challenges, they might not be as perfect as they ought to be, but we need to have a start. And that start talks about even interrogating some of the BEE challenges or prescripts that our senior colleague has identified. I might have missed on the other point that you said I must talk to. because I was cut off, but maybe you can remind me what issue it is that I need to address.
Okay, that's fine, SG. I think you've in the main, responded to the questions that were raised, and I'm very thankful for that. And I also don't want to, put more encumbrances upon you. But I would like to just read off this few messages. One is from Ntutu Njeza, who says, "Great feedback and conversation, Solicitor General Pandelani. Congratulations," and she's looking forward to the future, like I am as well from today. And of course, one is from M. Biko, who I think is your colleague, but says, "Good evening. Mine is just to confirm that as the state attorney, we are definitely embracing the strategies highlighted by the SG and bracing ourselves for the changes on the horizon. Nothing changes like change." Mr. Gambonani, can you please just round off our discussion for us and just before we close? Thank you.
Thank you very much, Mr. Mkonazi, and thank you very much to everyone for attending. When we conceptualized this seminar, we invited the minister. The minister said to me, "But Gambonane, you don't need me in this occasion of yours. You need the Solicitor General, and here are the numbers of the Solicitor General. Call him, you won't regret." Now I understand, Solicitor General, why the minister said we won't regret. I must confess that I agree with you, Mr. Mkonazi, that the Solicitor General is humble. I did not know the Solicitor General, and he did not know me too. But I called him, obviously. The Solicitor General, for the first time, answered my call with humility, with great simplicity and civility, and immediately said, "I'm available to assisting you." I felt so humble because we don't expect this Solicitor General from civil servant. When you call them, they don't even come back to you. When you send email, they don't reply. I was really humbled by you answering my call without knowing me and availing yourself. And now I understand the import of the position that you occupy. It is a very important position in our country and in the manner in which litigation is going to be conducted going forward. I see in the US, the appointment of the Solicitor General is actually done by the President, and it is confirmed by the Senate. Maybe in the US, they've long time appreciated the importance of this position. And Solicitor General, we also welcome the suggestion or rather the view from yourself that you intend creating a database of all practitioners. This database is welcomed, and we are looking forward to having it so that we can end this discrimination that exists between attorneys and advocates. And this database, we think that is going to contribute to the transformation of the entire legal profession, and is going to make sure that we have access to work. Why I'm raising this Solicitor General is because what makes a lot of particularly black practitioners to go to the banks, to join private sector, is not because they don't have skills, it's because they don't have access to work. Masego have already mentioned, and Masego, I also wish to thank you for joining us. By not knowing you, he ought to have known you. I have known Masego when I was a very, 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 very baby practitioner. Actually, one of the persons that touched about her name was Mr. Nixworth when I started lecturing at law school. To say you must learn from people like Me Ramachaka. He couldn't pronounce your name, but unfortunately Nixworth has now passed away. He was the first director at law school. He was passionate about legal education and development, and particularly about the empowerment of black attorneys. Thank you very much, Mematsego, also to you for joining us. And Tatem Konazi, I think we must make sure that Mematsego leaves her numbers. She is intensively experienced. We would need to tap into her skills as we go along. Mematsego, we welcome your suggestion that indeed the triple PFA need to be looked at. A lot of people have called for the review of this because it is an impediment to our growth as black practitioners. And also, we appreciate your input about the need to capacitate ourselves as black people. And we agree that when you look at our CVs, we are highly educated as Black people, and we have masters, some have doctorates in order to make sure that we are recognized. But I've realized that these qualifications are not going to make us to be recognized. What is going to make us to be recognized is to continue practicing law, staying in practice, do as many matters as we can, run away from this thing of specialization. I always tell my colleagues that I want to make money out of law, out of any area of law, as long as I can be able to tap these skills. So, Solicitor General, I see a lot of constitutional matters are given to so-called experts, and some of those experts happens to be white. And I ask myself to say, the Constitution started around 96 to be in we had an interim constitution and a final constitution. It was adopted in 1996. But now, Mema Seho has been practicing law before 1996, but she is not regarded as a constitutional expert. The Constitution started in 1996. White people are a constitutional expert. So my question is, who made them expert? Don't you think it's the state attorney that made them expert by giving them these constitutional matters? We also want to be constitutional expert. We welcome this database so that we can be constitutional expert. But I see that the time is gone now. I'm going to make sure that I am short. I just wanted to encourage all of us to embrace technology and to take advantage of this COVID-19 Solicitor General. And learn from this COVID-19 thing. I think that we've been litigating by Zoom, by Teams, and I see in the Labour Court they've been litigating a lot of, they're using Skype to litigate. And what I've seen generally, Solicitor General, is that this COVID-19 has really saved us time, because you can be able to do a lot of things during a short period of time. Last week, I had an urgent application in Middelburg Solicitor General at 10 o'clock. And from there, I was supposed to attend a meeting in Pretoria at 2 o'clock. And I had a last consultation at my office here in Rosebank around 4 o'clock. But I did all those things at home. And to travel from Johannesburg to Middelburg is about 2 hours. From Middelburg to Pretoria, 1.5 hours. From Pretoria to Joburg, 30 minutes. I did that in the comfort of my home. So I want to encourage us, all of us as practitioners, to welcome these COVID-19 issues, to welcome technology, because if you look at it in Memaseho, we can litigate anywhere in the world, Actually, I was speaking to my colleagues that since this COVID came in, I have a greater appetite of writing exams in other jurisdictions, like in London, your QLTT test, you can get admitted there as a solicitor. Some of us can write some exams in the US and practice whilst here in South Africa. So I think as practitioners, I know that ours is a very, very conservative profession. We are taught differently to be conservative. I think Daniel has touched on these things, that we must welcome technology. We must improve our systems, our filing systems. I see now we can upload documents. We don't have to go to court to serve and file. So I think that if we oil our machines, we welcome technology, we embrace technology, we continue to stay in practice with your support, Solicitor General. We think that as Black practitioners, we can be able to improve our skills and be able to transform the legal profession, because we can only transform the legal profession by staying in the profession. If we don't stay in the profession, we go and work for the banks and for private sectors. When the time comes for us to transform the legal profession, it is going to be very difficult for us, because we'll be outside. So we really thank you, Solicitor General, for having made taken off time from your family over the weekend to bless this occasion. And more importantly, I wish to thank you, Tatem Konazi, for arranging this occasion. It's very, very, very important. I think that with the support of people like the Solicitor General and Mayor Ramachacha, we can have a lot of these discussions, highlighting a lot of topical issues that are affecting us, particularly as Black practitioners, and see where we can assist each other. And more importantly, I want to thank all the participants for also having taken off time over the weekend to join this important session. We have shared ideas. The ideas that we have shared, I think that we are going to use them as a basis for coming up with other topics and having various discussions of this nature. And thank you very much to Medineo Peto. I see she's not joined us. She needs to be supported as a civil practitioner. We all know that women are still discriminated. They have to prove themselves a lot. I think we have a duty also, Solicitor General, in our briefing patterns to make sure that we capacitate our women. Actually, in my law firm, Solicitor General, when I want things to be done, I give them to women. You know, the time frames when I give men, it's too long. When I give women, you know, they have shorter time frames, and they look at these matters with an eye for women. There are certain things that they pick up that we as men cannot pick up, you know. So I think we need to support our women and involve them. But more importantly, thank you very much for attending, colleagues. Thanks, Solicitor General, for blessing this occasion, and thanks to you, Ntate Mkhwanazi, for making sure that we share our views. I hope that we will have many more events of this nature. We will try to make sure that we are joined by as many practitioners as we can. Enjoy your weekend. And Ntate Mkhwanazi, I will take the tapo ke di se go wena gore o tswalle this event. Thank you so much.
Thank you so much, Gambonani, for putting us in touch with the SG. Thank you once again, SG, and congratulations. And we are there to support you. We will be with you every step of the way. And colleagues, just note that our session was recorded, so I think our IT team will load it onto YouTube in a day or so. Thank you very much, and I'm looking forward to seeing you again in future. This is the end of our session. Have a lovely weekend further. Thank you and goodbye.
Thank you very much.
Yes, bye.